So good evening, everyone, and welcome. And thank you all so much for giving me an hour of your time this evening to discuss this very, very timely and critical topic. I'm Kathy Harper. That's me in my standard protest shirt, which bears my engagement mantra: organize, agitate, and educate. I am currently in my 5th year as a director on the AAUW California Board of Directors and as chair of the State Public Policy Committee. I had a comment at registration that someone wanted to hear from an attorney. So I hope you'll be pleased to know that I are an attorney. I am a retired prosecutor, as well as a former adjunct law professor. I taught law for 4 years. While I was a prosecutor in the DA's office, I headed the Law in Motion section, and I had an opportunity to argue 2 appeals before the California Supreme Court. So I hope you feel that I'm qualified to pontificate on the Dobbs case. All right, so let's get on with it. So why are we here? We're here tonight because on June 24th of this year, Justice Samuel Alito, a justice of the United States Supreme Court, otherwise known as SCOTUS, S-C-O-T-U-S, said this: abortion presents a profound moral question. The Constitution does not prohibit the citizens of each state from regulating or prohibiting abortion. Roe and Casey arrogated that authority. The court overrules those decisions and returns that authority to the people and their elected justices, to the people and their elected representatives. Tonight, we're going to discuss what that means. So of all the protest charts that are, pictures that are out there, graphs that are out there, this one I chose because it represents where we're going with our discussion tonight. We are going to go back. We're going to go back in pre-Roe to take a look to see how we got there. But we're also going to discuss, or I'm sorry, there's something on here I want to get rid of. We're also going to discuss our future. And I wish I could be optimistic, but I'm not particularly. All right, here's what we're going to cover. How did we get here? What the opinion does and doesn't say. What it means for women of California. What the post-Dobbs landscape looks like for all women. And what can and can't be done. So to help us understand this, how did we get here? We're going to have a brief historical review, and I'm going to put on my law professor hat. I'm going to take you inside a law school classroom. This happens to be my alma mater. Southwestern used to be called School of Law. So let's open those doors and begin what will be a semester's worth of legal education compressed into about an hour, probably a little bit more. First, I want to give you a quick review of the relationship between the U.S. Constitution, the U.S. Supreme Court, and the states. So we'll start with the Constitution. It is the source document for pretty much all of our laws. It establishes the relationship between governing bodies and those they govern, laying out the rights that the citizens have and the limitations government can set on those rights. Some of those rights are set out clearly, such as those found in the first 8 amendments of the Constitution, such as the right to free speech, to practice one's religion, the right to be free from unreasonable searches and seizures of our property, etc. These are called the enumerated rights. But as we know, what these words mean is actually not always so clear. For example, what exactly is speech? What constitutes an establishment of religion? What is an unreasonable search of property? And what happens when someone asserts a new right that wasn't specifically spelled out in the Constitution? So that's where SCOTUS comes in. The primary job of the High Court is to interpret the Constitution through scholarly analysis of existing laws, called precedents, to answer these questions. They are the final arbiter of all constitutional questions, and their decisions are binding on all courts, states, and citizens. So with that background, in order to understand how we got to Dobbs, we begin with the 14th Amendment to the United States Constitution. The 14th Amendment was enacted in 1868 as part of the Reconstruction Amendments. The 13th Amendment declared that slaves born in the United States were citizens. And the 14th made it clear that all citizens of the United States are entitled to its protections from the governmental restrictions, no matter what state they're in. So let's see what it says. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. In this clause, they're talking about the privileges and immunities are those enumerated rights that are found specifically in the first 8 amendments, and to some degree elsewhere in the Constitution, but specifically those enumerated rights. It goes on to say, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. So I want to come back to this third clause. Nor shall any state deprive any person of life, liberty, or property. The courts have come to call this substantive due process. Okay, and you'll hear that phrase consistently throughout the discussion of the cases that we're going to be talking about. So what exactly is meant by liberty? So previous courts have discussed this. I want to read quickly one that came out of 1897 and another that followed up in 1923. And the court in 1897 in Allgaier said, the liberty mentioned in the 14th Amendment means not only the right of the citizen to be free from the mere physical restraint of this person, as by incarceration, but the term is deemed to embrace the right of the citizen to be free in the enjoyment of all his faculties, to be free to use them in all lawful ways, to live and work where he will, and to earn his livelihood by any lawful calling. In 1923, the court followed on that in Meyer versus Nebraska and said, without doubt, the phrase denotes not merely freedom from bodily restraint, but also the right of the individual to contract, to engage in any of the common occupations of life, to acquire useful knowledge, to marry, to establish a home and bring up children, to worship God according to the dictates of his own conscience, and generally to enjoy those privileges long recognized at common law as essential to the orderly pursuit of happiness by free men. All right, so this understanding, so what the courts are doing in these cases and what they continue to do is whenever there is a new law, a new right that is asserted by a citizen or a group of citizens that is not part of the enumerated rights, the court looks to the 14th Amendment to see if they're somehow included in this concept of liberty. So with that background, we're going to take a look at our first case, Griswold versus Connecticut. This is a case that was decided in 1965, and it involved a Connecticut statute. Hold on, I want to back up. I want to say just a little bit about the titles you're going to see. Griswold, here it's Griswold versus Connecticut. So whenever you always have two parties to a case. One party is the party that's asking for some kind of relief from the court, and the other party has already won something and they are defending it. So in this case, Griswold is the party that is appealing to the United States Supreme Court. The cases have already, their case has already been heard in the lower courts. One party loses and one party wins. The losing party is always the one who brings the appeal. So in this case, the first name in the title is always what's called the appellant, the one who's bringing the appeal. So this case involves a Connecticut statute made it a crime for any person to use birth control. The executive director of the Planned Parenthood League of Connecticut, who's the executive director, his name was Griswold, so that's where we get the name in the title. And its medical director, a licensed physician, were convicted as accessories for giving married persons information and medical advice on how to prevent conception and for prescribing birth control for the wife's use. Griswold claimed that the statute violated the 14th Amendment. So before reaching its conclusion, the court does what courts do. They go through an analysis. And the court here looked at all of the prior cases, and this is how constitutional law gets interpreted. So we start with a precedent, and that establishes a concept of a new law that allows it to come within the concept of liberty. And then later courts use that decision when another new law is introduced, not the one that was in the other case, but now this is a new one. So they look at the prior case and they say, well, the court found a liberty interest there. So if we look at its reasoning, then maybe we can find a liberty interest in this new right that's being asserted. So that's what the court did here as it goes through its analysis. It looks at all these older cases, including the two that I read from. And the court says that these cases suggest that specific guarantees in the Bill of Rights have penumbras that give them life and substance. It's a funny word, but this is the first time we hear this word in the court's decision in Griswold. And a penumbra is essentially, it's that kind of fuzzy area outside of an object. And the court says that if you look at that area just on the outside of the actual right, you'll see that there's words that give that right life and substance. That helps us understand what it really means and why it's there. The court also looked at the 9th Amendment of the Constitution, which says the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So this is the clause that gives the court the right to go outside those enumerated specific rights and look to see what the substance, that's why we call it substantive due process, to see what the substance of the law is. And then finally, the court relied on the 4th Amendment's right to unreasonable searches and seizures and says from that, what the founders meant to establish was a right to privacy in one's home. That's the only reason they would not allow the government to intrude, obviously, because they felt that people have a right to privacy in their own homes. So from that, the court gleaned a right to privacy within the constraints of the Liberty Clause of the 14th Amendment. Based on all that, the court held the Connecticut statute forbidding the use of contraceptives violates the right of marital privacy. So this is a brand new right now that we get out of Connecticut, Griswold versus Connecticut. It's nowhere enumerated in the Constitution, but we now have a right to marital privacy that comes out of the penumbra of the other rights, enumerated rights. All right, we go ahead a decade. And now we have someone challenging, also asserting another new right. This is Roe versus Wade, 1973 was decided. And Roe versus Wade involved a Texas statute making abortion a crime. Jane Roe is the appellant here. It means she lost in the lower court, so she's bringing this appeal to the Supreme Court. She was an unmarried Texas woman who wanted an abortion. Wade was the district attorney of Dallas County who was charged with enforcing the Texas statute. Jane Roe wanted what we call declaratory relief. She didn't want to get the abortion and then face being in prison for violating the law. She wanted to get the court to declare ahead of time that the law was invalid. So again, the court goes through this analysis, and it starts with Griswold, and it accepts the Griswold finding of a right of personal privacy in the penumbras of the enumerated rights. But it goes the next step, and it says not only is personal privacy come from the rights themselves, but it also comes from the concept of liberty found in the 14th Amendment. So now we have a substantive right, 14th Amendment right analysis. It says other cases establish that the concept of liberty in the 14th Amendment encompasses the right to, quote, generally enjoy those privileges long recognized at common law as essential to the orderly pursuit of happiness by free men. The court then goes on to say, however, basically this is not an absolute right. Only personal rights that can be deemed fundamental or implicit in the concept of ordered liberty are guaranteed in this guarantee of personal privacy. And the court recognizes that states may sometimes have compelling reasons to regulate abortion, such as to protect the mother's health. This is specifically stated by the court as such a compelling, one of those compelling reasons why the state may want to regulate abortion. The focus is on the mother's health. So applying these principles, the court finds, we call this a holding, so the court held, number one, that the right to privacy does encompass a woman's decision whether or not to terminate her pregnancy. But again, the court says the right is not absolute. States have legitimate interest in seeing to it that abortions are performed safely. Where's the focus of the state's legitimate interest? A woman's safety. The court balanced these interests and concluded, this is where the court comes up with the tri-semester scheme. It says prior to the end of the first trimester of pregnancy, this is a fundamental right to decide whether or not to terminate her pregnancy. And because it's a fundamental right, the state may not interfere with or regulate a physician's decision that the patient's pregnancy should be terminated. At the end of the first trimester, and up until the point in time when the fetus becomes viable, the state may regulate the procedure, but only to the extent that such regulation relates to the preservation and protection of maternal health. So if you think about this as a scale of balance, you've got the rights of women that have now been established through Griswold, and now Roe is reinforcing that. So you've got the legitimate rights of the woman, which is a fundamental right to make her own decision. You've got the counterbalancing rights of the state. In the first trimester, it's here. The woman's interests have top priority. They cannot be interfered with by the state. In the second trimester, that other side starts coming up, and the pregnant woman, a patient gets her rights recognized. To some extent, the state gets their interests recognized, but only that right to regulate women's health within their state. From and after that point in time, when the fetus becomes viable, now the scales have completely upended, and now the state's rights kick in. Now, but only when the fetus becomes viable. So from and after that point in time, when the fetus becomes viable, the state may prohibit abortions altogether. So this is the first time in this final three-part holding of the court that the fetus is even mentioned, that we even get any recognition that the rights of the fetus or the fetus itself the state has any interest in protecting the fetus. All through Griswold and all through the bulk of the Roe analysis, the focus is on protecting the mother's health. It's only at that point when the fetus becomes viable does the court recognize that the state has an interest in protecting the fetus. And still, it's the necessity to preserve the life or health of the mother outweighs that the right of the fetus, or the right of the state to protect the fetus. And in fact, the court specifically states in the decision that, quote, the unborn are not included within the definition of person as used in the 14th Amendment. I want you to remember that because it becomes really important as we go through the Dobbs analysis. All right, so what happens? Over the next 2 decades, anti-abortion states begin enacting a flurry of new laws designed to push the boundaries of Roe's holding, most of them testing just how far they can go in furtherance of, quote, protecting the health of the mother in that second trimester. Many of these cases reach their state appellate courts and the lower federal courts, and the decisions of those courts are all over the place. None of the courts can agree on when those boundaries have been reached. Many of the losers of those cases in the lower courts asked the United States Supreme Court to intervene, but SCOTUS consistently refrains from doing so for 20 years. For 2 decades, they get appeal after appeal after appeal, and they refuse to hear them. The Supreme Court is not obligated to take every case on appeal that's brought to it. It can pick and choose, and it picks very few cases, and it picks very selectively. And so, excuse me, so for 20 years, the court says, no, Roe is the law, Roe's the law, and You guys figure it out. Finally, in 1992, the court agrees to take up an abortion case. And the decision is written by Justice Sandra Day O'Connor, and she actually says in her opening that the time has come, there's been so much confusion and so many differing opinions. We need to put an end to this. We need to settle this once and for all and come up with a decision that everybody can understand and follow, and we can cease with all this endless litigation. So that case that they agree to take is Planned Parenthood versus Casey in 1992. This case involves the Abortion Control Act of Pennsylvania, which required 5 things, but we're only going to talk about 2 that are relevant. First, it provided that a woman must be provided pro-birth information at least 24 hours before the abortion surgery. And 2, that a married woman must sign a form saying that she has informed her husband. Planned Parenthood, not surprisingly, argued that the statute was unconstitutional in violation of Roe and the 14th Amendment. So again, let's take a look at the court's analysis. Remember, this is Justice Sandra Day O'Connor writing for the majority. So she recognizes right off the bat that Roe determined that a woman's decision to terminate her pregnancy is a liberty protected against state interference by the substantive component of the Due Process Clause of the 14th Amendment. She then recognizes that the adjudication of substantive due process claims requires the court to determine the boundaries between the individual's liberty and the demands of organized society. So again, that balancing of the scales that I was talking about before. She goes on to recognize that Roe's central holding, she declares, it properly invoked the reasoning and tradition of the precedents upon which it relied to establish a woman's right to terminate her pregnancy. So this means that she has gone through all those precedents. She's looked at, okay, why was Roe decided? What was the reasoning behind it? She looks at all those cases and she comes to the same conclusion. When I say she, again, this is not just her, but it's her speaking on behalf of the majority. So at least 5 justices have agreed with her. So Roe's, she says Roe's central holding properly invoked the reasoning tradition of the precedents. Although Roe has engendered opposition, she recognizes, it has in no sense proven unworkable. These next 3 phrases are really, really critical to understanding how the court has shifted in the time of Dobbs. In this decision, she recognizes these 3 things. For 2 decades, people have organized their intimate relationships and made choices that define their views of themselves and their places in society in reliance on the availability of abortion in the event that contraception should fail. Second, that the ability of women to participate equally in the economic and social life of the nation has been facilitated by their ability to control their reproductive lives. So this proves that the Roe decision was very workable. It has actually had a very good success. It's been productive. It's achieved what it set out to. It has had a good outcome for women in the country. And finally, she says no change in Roe's factual underpinning. There's nothing in this Casey case that has changed anything that was present before us in the Roe decision. Nothing in that has left its central holding obsolete, and none supports an argument for its overruling. So first she says that based on a review of all the cases and of the reasoning in Roe, the decision should stand. And then she looks at the second factor, and that is she does an analysis under stare decisis. Stare decisis is a Latin term, and it essentially means the thing has been decided. And it's a really critical component of American jurisprudence. It means that we have a right to rely on the decisions of the court. We've selected them to be have the final voice, and that when they say what the law is, we can trust that, and we can order our lives around that, and we can trust that it's not going to be changed willy-nilly the next time a new court comes on the bench. So that's, in a nutshell, what stare decisis means. So under her stare decisis analysis, she makes the following findings. Overruling Roe's central holding would seriously weaken the court's capacity to exercise the judicial power and to function as a Supreme Court of a nation dedicated to the rule of law. Where the court acts to resolve the sort of unique, intensely divisive controversy reflected in Roe, its decision has a dimension not present in normal cases and is entitled to rare precedential force, not presidential, precedential force to counter the inevitable efforts to overturn it and to thwart its implementation. And this is another one of those phrases I really hope you will remember when we start looking at Dobbs, because what we'll see in Dobbs is that Justice Alito takes this phrasing, this stare decisis analysis segment, and completely flips it and turns it on its head. Her focus here is that, yes, she recognizes this is divisive, controversial, that this is not, that abortion cases are not normal cases because they give rise to a great deal of controversy. And just because of that, it is entitled to even more precedential force than other cases, because this is an issue that needs to be resolved. We can't just go on forever having states trying to overturn this law. This is her hope that this will settle it once and for all. She says only the most convincing justification after accepted standards of precedent could suffice to demonstrate that a later decision overruling the first was anything but a surrender to political pressure. Without it, the country would suffer a loss of confidence in the judiciary, and a decision to overrule Roe's essential holding under the existing circumstances would address error, if there was any, at the cost of both profound and unnecessary damage to the court's legitimacy and to the nation's commitment to the rule of law. So why have I highlighted these in these last 3 bullet points here? You might guess when you think about the damage that Dobbs has done. This was all foretold by Justice Day O'Connor in her decision in Casey. So given that analysis, this is the holding in Casey. She found that, you're going to find the holding a little bit surprising. She upheld Roe, yay, but actually agreed with Casey in the state of Pennsylvania, and also upheld the Pennsylvania law, Pennsylvania Abortion Act. So she found that Roe's essential holding should be retained and reaffirmed as to each of its 3 parts, which consisted of a woman's right to choose, confirmation that the state had a power to restrict abortions after viability, and that the principle that the state has legitimate interest from the outset in protecting the health of the woman. And again, language is very important. You can see I violated the first rule of presentations. I have lots and lots of content on these slides, and that's usually a no-no, but I wanted you to hear the language that the courts use in all 3 of these cases that I'm discussing, because language is critical in the law. So she says, this is a phrase she uses, in protecting the health of the woman and the life of the fetus that may become a child. So the decision has been made that the fetus is only going to be recognized as having a stake in this when it becomes viable, when it's reached that point where it may actually become a child. That's the first time that right is recognized. In her second holding, in balancing the right of the woman to make her own decision against the legitimate interests of the state, this is something new that comes out of Casey, the undue burden standard should be employed. So in other words, what she's doing here is saying, we're settling this once and for all. If you have any other questions about how to apply this law, you use this standard. You look at the state prohibition that you're trying to enact, and you ask yourself, does it place a substantial obstacle in the way of a woman getting an abortion? If it does, then it is creating an undue burden, and it will not stand. So don't even bother enacting it. She's thinking that this is going to put it to rest. This is an easy standard to follow, and states should be able to understand this. So this is the undue burden standard that's established. But then she goes on to say, Roe's rigid trimester framework is rejected. It's too rigid. It isn't necessary. The key word in the Roe decision was viability. That's the only thing that matters. That's the only thing that we have to think about is abortions are allowed basically up until the point of viability, end of discussion. Okay, so great. She then goes on to say, however, in this case, we find that it's okay to require counseling when the purpose is to persuade the woman to choose childbirth over abortion, or when the government requires, as it does here, the giving of truthful, non-misleading information about the nature of the abortion procedure, the attendant health risks and those of childbirth, and the probable gestational age of the fetus. So she upholds the part of the Pennsylvania law that says that women have to be informed of the dangers and health risks, et cetera, of the abortion 24 hours ahead of time. But she also concludes that the other provision is unconstitutional. The husband notification provision constitutes an undue burden and is therefore invalid. Okay. So at this point, I'm going to stop for just a minute and open it up for just a couple of questions. I do want to say I read all of your questions that were put in the comments column at the time of your registration, and I've tried to incorporate all of those questions, all but just a couple, I think, into my presentation. So we're going to take a couple of questions at this time, but I'd like you to keep them limited to just section 1, what I've just covered, the history, so that we can move on to looking at the Dobbs case. So Linda, what do you have for me?
Actually, Kathy, there were no questions put in Q&A regarding this section 1.
Oh, okay. Yay, you all passed law school 101. You all got it. Then we're going to just go ahead and move right into the next section, and we're going to talk about Dobbs versus Jackson Women's Health Organization, what it does and doesn't say. So here we are, 2 decades after Casey and 50 years after Roe. And SCOTUS agrees once again to consider the question of states' rights versus a woman's right to choose. But we have a very different Supreme Court now, don't we? Years in the making, this court now has 6 very conservative justices, all of whom have long-standing anti-abortion records. So along comes this case from Mississippi. Let's take a look. So I'm going to reverse the question, and I'm going to start with what Dobbs doesn't say, because that's easy and we can dispense with it and get on to the real discussion. Dobbs does not say it's illegal for women to get an abortion. I want to emphasize this. I have been doing tons and tons of reading since the 24th, and I can't tell you how many times I've heard or read about people saying Dobbs has ruled that women can no longer get abortions in the United States of America. That is not what Dobbs says. Okay, what does it say? So what you're going to see in the next couple of slides is language from the decision. And as I mentioned, Justice Samuel Alito wrote this decision. He wrote it on behalf of the majority. So again, that means that 5, as we know, not giving anything away, as we know, he ends up overruling Roe and Casey. What happens is the court meets initially when a case comes up, when they agree to take a case, and they take an initial vote just to see how many are in favor of reversing or upholding. And if 5 votes are given one way or the other, 5 or more, all it takes is 5, that's the majority, then the decision is that the decision is going to come out as a reversal or a confirmation. Once that's determined, then the Chief Justice assigns one of those justices who are in the majority to write the opinion, what's called the majority opinion. And the majority opinion becomes the one that is eventually precedent. So future cases can only rely on the language in the majority opinion. In this case, Justice Alito was chosen to write the majority opinion on behalf of the 5 reversing well, that has a little bit of caveat too, but I'll get into that later. But on behalf of those 5 justices, however, 3 of the justices write concurring opinions as well. So the language that you're going to see really reflects that not only the holding, but the reasoning, the analysis of Justice Alito, Justice Coney Barrett, and Justice Gorsuch. The other 3 in the majority wrote their own opinion. There were 6. They wrote their own concurring opinions. So this language reflects the reasoning and analysis of those 3 justices that I named. All right, so what is this case about? It involves Mississippi's Gestational Age Act, which provides, quote, except in a medical emergency or in the case of a severe fetal abnormality, a person shall not intentionally or knowingly perform or induce an abortion of an unborn human being if the probable gestational age of the unborn human being has been determined to be greater than 15 weeks. That's all it says. Anybody notice what's missing? Does anybody see in that law, in that act, anything that says abortion shall henceforth be illegal in the state of Mississippi at any stage of the pregnancy? No, it does not. It simply says, it simply removes the viability language that we get out of Roe and Casey and replaces it with a very specific end time, that boundary that Justice O'Connor was talking about. It sets that boundary where the women's interest comes up against a boundary of 15 weeks in Mississippi. And Jackson Women's Health Organization is an abortion clinic, and they challenged the act, alleging that it violated Roe versus Wade and Planned Parenthood. Okay, now this last bullet point, this is Justice Alito speaking, and he says, petitioners appeal on the grounds that Roe and Casey were wrongly decided and that the act is unconstitutional because it satisfies rational basis review. But here's the thing, that was not the basis of Mississippi's appeal. Courts are only supposed to decide on the one question or the question or questions raised by the appealing party, not make up their own issue. I have read the state's petition for writ of certiorari. That's the petition that the losing party below files what's called a writ of certiorari, and they send that to the court and say, we're filing this writ asking you to please take our appeal and resolve our questions. And in that writ of certiorari, on the very first page, they say Mississippi files this writ to resolve the following questions. And here were the questions that were laid out in the writ of cert for cert in Mississippi's petition. First, question 1, whether all pre-viability prohibitions on abortions are unconstitutional. Not whether abortion is unconstitutional, but whether pre-viability prohibitions are unconstitutional, whether or not all of them, in their case, 15 weeks, and whether the court in balancing the competing interests should use Casey's undue burden test or should balance the relative benefits and burdens to all parties, including, quote, in their language, the dignity of unborn children. Those are the 2 questions put to this court. But Justice Alito ignores that and states in his opinion that the petitioner's appeal on the grounds that Roe and Case were wrongly decided and need to be reversed. This court, in my opinion, some of you may share that opinion, has just been itching to overturn Roe and Casey. So that's how they decided to frame the issue. And based on that, Justice Alito, writing for the majority, concludes these 3 things. The Constitution does not confer a right to abortion. Roe and Casey are overruled, and the authority to regulate abortion is returned to the people and their elected representatives, meaning basically the states. So now we're going to go in reverse order. I'm giving you the holding first. Now we're going to look at the court's analysis to see if we can figure out how he got there. So he starts his analysis by saying these 3 things. The critical question is whether the Constitution, properly understood, confers a right to obtain an abortion. Casey's controlling opinion skipped over that question and reaffirmed Roe solely on the basis of stare decisis, and a proper application of stare decisis requires an assessment of the strength of the grounds on which Roe was based. So again, in my humble opinion, this first part of this analysis is just dripping with Justice Alito's arrogance. He thinks he is the only one who can administer who can properly understand the constitutional question here. He thinks that he alone is capable of giving a proper application or understanding a proper application of stare decisis. He is completely misstating the truth when he says the Casey's opinion skipped over the questions and reaffirmed based solely on the basis of stare decisis. We just went through the court's analysis in Casey's decision, and we saw how very careful Justice Day O'Connor was in going back and looking at the precedents and reaching the conclusion that it was rightly decided. But nevertheless, Justice Alito goes on to give his proper analysis, and he concludes first that the right to an abortion is not a fundamental right. He says that an unenumerated right enjoys 14th Amendment protection only if it is deeply rooted in our history and tradition, and if it is essential to this nation's scheme of ordered liberty. In interpreting what is meant by liberty, the court must guard against the natural human tendency to confuse what the 14th Amendment protects with the court's own ardent views about the liberty that Americans should enjoy. And this clause just cracks me up because in this clause, he's accusing prior courts of making their decision based on their tendency to decide what liberties people should enjoy, when in fact his whole opinion shows that he is the one who's doing exactly that. He breaks it down. He says the reason it's not a fundamental right is because it's not rooted in our history. He goes way back to the 18th century and relies on legal scholars who wrote that post-quickening abortion was a crime in the 1700s. And it's kind of funny that he used this as part of his basis of his decision, because post-quickening basically means viability. So that sort of supports the finding in Casey. He also looks at the time that the 14th Amendment was adopted in 1868, when he says 3/4 of the states had made abortion a crime at any stage of pregnancy. And he says this consensus endured until the day Roe was decided. Well, the day Roe was decided was in 1973, and in 1973, 30 states had anti-abortion laws. By my math, 3/4 of 50 is 38, not 30, so that was not even accurate. And then he concludes that Roe either ignored or misstated this history, and Casey declined to reconsider Roe's faulty historical analysis. Well, they both engaged in a very thorough historical analysis, and it's only faulty because it disagreed with the conclusion that Alito wanted to reach. The second reason that he found it's not a fundamental right is because he said it's not part of ordered liberty. According to Justice Alito, ordered liberty sets limits and defines the boundary between competing interests. Well, isn't this exactly what Justice Day O'Connor said in Casey? He says Roe and Casey each struck a particular balance between the interests of a woman who wants an abortion and the interests of what they term potential life. But remember, this was not the balance that was struck in either of these cases. The competing state interests that those justices in Roe and Casey recognized was the interest in the mother's health. Neither of the courts even talked about, Roe didn't talk about potential life at all, and Casey only recognized viability, potential life, as in her discussion of the third trimester holding. So that is not the balance that the court focused on in the other two cases. And then he says the people of the various states may evaluate those interests differently. Well, so what? Various states frequently disagree on what the Constitution does and does not prohibit. That's why we have SCOTUS to make that decision, those final decisions. His second finding is that the finding of a fundamental right is not supported by precedents. And this is that clause where I told you to remember from the Casey decision where Justice O'Connor talks about why it's so important to uphold the law is because it's not, abortion cases aren't normal cases because it's so divisive. This is where I talk about Justice Alito kind of turning that on its head. He says, what sharply distinguishes the abortion right from the rights recognized in the cases on which Roe and Casey rely is this. Abortion is different because it destroys what Roe termed potential life and what the law challenged in this case calls an unborn human being. So in this analysis, we have moved completely away from the focus being on the health, well-being, and rights of the mother, and shifted for the first time the focus on the fetus. This will be critical to our analysis of the future of abortion rights. In the second bullet point here, he says none of the other decisions cited by Roe and Casey involve the critical moral question posed by abortion. This is the first time that this question has been approached by the courts as a moral issue. I suggest to you that this is a product of Alito's own religious background than one of proper judicial analysis. Finally, he says, accordingly, these cases do not support the right to an abortion. And finally, he gets around to stare decisis, because obviously the court's going to be significantly challenged on why they would reverse these cases, these long-standing 50 years of precedents. And he goes through the 5 factors that a court should consider. First is nature of the court's error. He finds it egregious here because those who seek to protect fetal life no longer have a say. Well, the losing party of any thing that's in contention no longer has a right to say. The winning party gets the final word. It shouldn't be treated any differently, but because it involves fetal life, as we can see, Alito finds it's different. The quality of the reasoning, again, he finds that Roe has no grounding in the contextual text, history, or precedent. Those justices didn't know what they were talking about, only I do. Workability, Casey's undue burden test has generated too much litigation. Well, at the very end of this presentation, I've included 2 slides that have a long list of resources for you if you want to do some further research on your own. One of them talks about the endless litigation. It goes on and on and on for pages of how much, all the different legal issues that have been raised by the Dobbs decision and how long this is going to be, these issues are going to be litigated in the courts. He cites effect on other areas of law, claims that Roe and Casey have led to the distortion of many important but unrelated legal doctrines, but doesn't bother saying what any of those are, doesn't cite a single one. And finally, the reliance interests have to be considered. And remember where Justice O'Connor said, because women have relied on the holding in Roe and have ordered their lives around it, that's one of the main reasons why it should be upheld. Justice Alito finds overruling Roe and Casey will not upend concrete reliance interests like those that develop in, quote, cases involving property and contract rights. So ladies, what he's saying here, our right to make decisions about our own bodies are not even as important as property and contract rights. And he says that Roe and Casey failed to consider the effects of the ruling that, on the status of the fetus, which is where he wanted to go all along. All right, so that's basically the everything that I think you need to know about the majority opinion and how we got there. But I've also included some of the other opinions because their language is important for different reasons. So I'm going to have to go through these quickly because we're getting close to time. So first we're going to look at Justice Clarence Thomas's concurring opinion. And this cracked me up. He also goes through a long analysis to support his position, basically he writes a concurring opinion because not only does he agree that Roe versus Wade should be overturned, but he thinks that the whole concept of substantive due process should be thrown out, that no court in no case should use this substantive due process analysis of liberty based on the 14th Amendment. So to support that position, he also goes through a long analysis of prior cases, but all the prior cases that he cites, he only cites his own words in his dissenting opinions. He doesn't cite the language from many other justices who agree with him, because basically none do. So yeah, he says substantive due process is an oxymoron that lacks any basis in the Constitution. And he goes on to say, in future cases, we should reconsider all of this court's substantive due process precedents, including Griswold, which involved the right to birth control, Lawrence, a case called Lawrence, which involved the right to private consensual sexual activity, and Obergefell, which granted the right to same-sex marriage. What's missing from his list is a case called Loving versus Virginia. This case involved interracial right for interracial couples to marry. Many of you probably know, some may not. Justice Thomas is Black. His wife, Ginny Thomas, yes, Ginny Thomas of insurrection fame, is white. And he does not even mention Loving. However, interestingly, Justice Kavanaugh, in his concurring opinion, does. He writes separately to address this very issue because he seems to be concerned about this. On the question of how this decision will affect other precedents involving issues such as contraception and marriage, in particular the decisions in Griswold, Eisenstadt, that was another birth control case, Loving versus Virginia, and Obergefell versus Hodges, I emphasize what the court today states. Justice Alito also stated this, kind of in a footnote. Overruling Roe does not mean the overruling of those precedents and does not threaten or cast doubt on those precedents. Well, I'm sorry, but it casts incredible doubt on those precedents. The question that came to my mind is, well, why not? If the reasoning in Roe and Casey was flawed, how can you say it was not flawed in these other cases? The dissent opinion addresses this at length. We'll look at that in a minute. And finally, the concurring opinion of Chief Justice Roberts, who his opinion is really interesting. He would have voted to uphold Roe and Casey and affirm a woman's right to choose, and only address, as he recognizes, as I stated before, the only question raised by Mississippi: should the viability test be abandoned? He agreed that it should. So that's why he was in the majority, because he went along with the majority in upholding the law, the Mississippi law, but he basically dissented in the other portions, overturning Roe and Casey. So let's look real quickly at the dissenting opinion. Now, the dissenting opinion was written by Justice Sotomayor, but was joined by the other two liberal justices. So they all agreed on everything that was in it, and that just said that she appointed her to be the actual author. So this represents all of their opinion. So she says Roe is in three parts. The first part says, one result of today's decision is certain: the curtailment of women's rights and of their status as free and equal citizens. Yesterday, the Constitution guaranteed that a woman confronted with an unplanned pregnancy could, within reasonable limits, make her own decision about whether to bear a child, with all the life-transforming consequences that act involves. And in thus safeguarding each woman's reproductive freedom, the Constitution also protected, quote, the ability of women to participate equally in this nation's economic and social life. But no longer. As of today, this court holds a state can always force a woman to give birth, prohibiting even the earliest abortions. A state can thus transform what, when freely undertaken, is a wonder into what, when forced, may become a nightmare. In part two, she addressed this issue. No one should be confident that this majority is done with its work. The right Roe and Casey recognized does not stand alone. To the contrary, the court has linked it for decades to other settled freedoms involving bodily integrity, familial relationships, and procreation. Most obviously, the right to terminate a pregnancy arose straight out of the right to purchase and use contraception. See Griswold and Eisenstadt. In turn, those rights led more recently to rights of same-sex intimacy and marriage. See Lawrence and Obergefell. They are all part of the same constitutional fabric protecting autonomous decision-making over the most personal of life decisions. Either the majority does not really believe its own reasoning, or if it does, all rights that have no history stretching back to the mid-19th century are insecure. Either the mass of the majority's opinion is hypocrisy, which I believe it is, or additional constitutional rights are under threat. It is one or the other. And finally, the dissent concludes, the court reverses course today for one reason and one reason only, because the composition of this court has changed. Stare decisis, this court has often said, contributes to the actual and perceived integrity of the judicial process by ensuring that decisions are founded in the law rather than in the proclivities of individuals. Today, the proclivities of individuals rule. The court departs from its obligation to faithfully and impartially apply the law. We dissent. And with that, I will open it up to questions on section 2.
Yes, there are 3 questions.
Okay.
The first is, why did the Supreme Court allow a man to do the analysis of the case rather than a woman, justice, who might be better understand what the decision means? And then I'm going to do the second question with it, and it's by the same person. If Alito's decision is improperly reached and not supported by law, why is it not means a question, appeal, or overturn that decision?
Okay, I'll take the first part first. The only female justice who was in the majority was Justice Coney Barrett, and she essentially agreed in all aspects with Alito. So it wasn't a matter of who the author was. He was chosen by Chief Justice Roberts to be the author because of the 5 in the majority. He was the senior justice on the court. But if Coney Barrett had written this decision, trust me, it would have said exactly the same thing. It would not have made any difference whatsoever. Why can't it be reversed if it was improperly analyzed? Because, as I said before, the Supreme Court has the final word on any issue that involves a challenge to the Constitution or the creation of a new right from the Constitution, any law that is of constitutional magnitude. The Supreme Court is called the High Court because they are the highest court in the land. They have the final say-so on interpreting the Constitution, and there is no other one. There's nobody else to appeal to. So that their decision stands, for good or bad.
And the final question that we'll talk about right now. So does that mean that the rule of law is meaningless and might is right?
It's not really a question of might is right. It only in the sense that, yes, the majority on the Supreme Court gets to write the majority opinion. So that means 5 out of 4. We call that a plurality opinion because it's not unanimous or because it doesn't have a clear majority. This one actually had 6, but look at all the different concurring opinions. So not everybody agreed on everything in the majority opinion. But your first question is very valid. And if you think about all that language that I highlighted, look at in Justice O'Connor's opinion, the language that I highlighted in those last 3 bullet points where she said, if we reverse this is what's going to happen. People will have this exact question. Does that mean the rule of law is out the window? We can no longer depend or rely on a Supreme Court who will make reasoned judgment on behalf of all peoples, that they will only make decisions based on how they want the outcome to be. And she was very, very concerned about that and felt that, among other reasons, was one of the main reasons why it was important not to overrule Roe. And Justice Alito just basically gave very short shrift to that. The bottom line is, in this decision, Justice Alito knew what result he wanted to reach before he started his analysis. And he found ways to get around stare decisis in order to reach that opinion. So yes, I think that there will be a significant portion of our populace who will lose confidence in the Supreme Court because of this poor reasoning. And in fact, the Supreme Court traditionally, historically, has always enjoyed the highest support of the American populace, of all the three branches, more than the president, more than Congress. The Supreme Court has always been up in the 60s, 70s, 80s. The Supreme Court popularity dipped to 30% of the nation after this decision came out. So that's kind of where we are and what we're stuck with. I told you I wasn't going to be very optimistic. Okay, are we ready to move on? Yes, Linda, that's all the questions? Okay, or Randa said that. Okay, so right, so now we're gonna look to the future. So what does this mean for, we're gonna do two parts here. What does it mean for California, and what does it mean for women all across the United States? So a lot of you had questions about this, about how it affects California, and I've incorporated your questions in here. I hope we've got them all. So what is the current law in the state of California? It's found in California Health and Safety Code 123462. This law was decided, it was enacted in 2002, and it says the state may not deny or interfere with a woman's right to choose or obtain an abortion prior to viability of the fetus, or when the abortion is necessary to protect the life or health of the woman. So we are a pro-choice state by statute. Yay. And it's good that we have this law. We're safe, right? Well, some of you have questions as to whether or not that's true. What is the effect of Dobbs, if any, on our statute? One question was, does Dobbs overrule the California statute? The answer is very clearly and easily no. It leaves it to the states to choose if they want to legalize or outlaw. We have chosen to legalize, and that decision will stand unless something else happens, and that leads us to the next two questions. Can a future SCOTUS case invalidate our law? My answer is maybe. It's complicated. Everything in the law is complicated. When I was a law professor, my answer to all my students' questions was always maybe or it depends, because it's never simple. So here's why it's complicated. As I said, the High Court can't just announce a new law. They can only decide questions that are raised in the cases that are brought to them or that they choose to grant certiorari on. The court can only invalidate a law that is in violation of the U.S. Constitution. So Alito said that's what happened there, even though we don't necessarily agree, but that was his determination. So the only way a court could find that our law violates the Constitution is this. It's a multi-state process. So first of all, some state somewhere, some anti-abortion state, will have to enact a law that says essentially life begins at conception or life begins at heartbeat. We've already seen that. We have lots of these so-called heartbeat laws already being enacted. We have more pending. But life begins at whatever point that state chooses. And it's before viability. And so the law says life begins at blah, 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 and therefore the embryo or the fetus is entitled to personhood as a citizen of the United States. Okay, so let's say that imaginary law that comes out of some state, and that's what it says. Someone with standing in that state decides to challenge that law. They decide to say, that's unconstitutional. There's nothing in the Constitution that says a fetus is a person or deserves citizenhood. So therefore, this law that the state has enacted is in violation of the Constitution. I'm going to litigate this in court. So they take it to court, they challenge it, it's heard in the lower courts, the lower courts make their decision, and at some point it makes its way up to the Supreme Court. So the next step is now the Supreme Court has to agree to take it. Again, that's not guaranteed. So let's say it does. So now it gets in the hands of the Supreme Court. And so in this imaginary scenario, SCOTUS agrees. SCOTUS takes the case, they look at it, and they agree. And by agreeing, they confer citizenship upon the unborn at any stage. That would be tantamount to giving the fetus or even the embryo personhood. So a law like ours that says no person can be denied the right to have an abortion before viability, that would be tantamount to denying a citizen life, right? A citizen now is the embryo. So now we have two citizens. We have the mother is a citizen, but now all of a sudden the Supreme Court has determined that the embryo or the fetus is also a person. And the 14th Amendment says, if you remember, that no state shall deny a citizen of the United States or of any state the right to life. So if our statutes, it has the effect of denying life to that fetus by allowing the mother to abort it, we're in violation of the 14th Amendment. So that would be a way and the only way in my analysis that a future SCOTUS case could invalidate our law. Is it far-fetched? I don't think so. It's a complicated process, but this Supreme Court majority is going to be around for a long time. The Federalist Society saw to that by putting forth its youngest viable candidates, and they are not about to change their mind. So I think this is a possibility. Probability, I don't know, but certainly a possibility. Okay, then the next question is, can Congress pass a law that would validate our law? And my answer here, I'm a little more optimistic. I say probably not. And generally, Congress can't pass a law, any law that dictates state laws. Congress can only basically pass laws that govern federal interactions, federal activity, not states. They can't dictate states' rights unless there is a constitutional basis to do so, or it involves a transaction between or among states. Congress also can't pass a law that conflicts with a Supreme Court decision that is based on an interpretation of the Constitution. The Constitution confers the right to interpret the Constitution only on the Supreme Court, not Congress. So at this point, SCOTUS has said that it is up to each state to decide, and Congress can't override that. So I don't think that's going to happen. Not that they won't try, and they may even be successful in passing it, but I don't think it would pass constitutional muster. All right, so what does the post-Dobbs landscape look like for other states? I just put this up here as kind of a quick visual. The red states here is where the abortion has already been banned. The orange states are states that haven't come up with an outright ban yet, but they have placed severe restrictions. And the yellows are states where abortion restriction laws are pending. All the green states are pro-choice states. And it's there's 26 pro-choice states, I think, right now. The various positions of the states, some of these terms that you may have heard, trigger laws, this pertains to states who previously enacted laws after Roe came out, and they enacted an anti-abortion law knowing that it couldn't take effect, that it would be unconstitutional, but they put a trigger in there, and they said this law will become effective immediately. Will become effective upon the overruling of Roe versus Wade. Some states said it will take effect immediately, and some of those have already gone into effect. Others say within 30 days or 60 days after the overruling of Roe. So they've got a waiting period, basically to see if there's a new legislature, new legislators who might have a different opinion and might change their mind. Some states have pre-Roe bans that were never repealed. These go back before 1970, before 1960, before 1973, and when they were on the books, when Roe became effective, when Roe was decided, it had the effect of annulling those laws. They couldn't go into effect, but they were never formally repealed, so they're still sitting on the books. So a question in those states is, are those automatically reenacted? Do they have to go through some legal process? Do they have to be repealed and then the new law enacted? All of these are legal questions that are going to be litigated for quite some time. We don't have answers right now. Already in 3 courts, Florida, Kentucky, and Louisiana, state courts have blocked enforcement of their state's anti-abortion bans while these issues are litigated. Some states have already decided that they're going to keep the tenets of Roe and Casey intact, but they're going to place significant restrictions. And then some states have followed Texas' lead and enacted these civil enforcement laws where they give authority to their citizens to basically, form a posse and go after people for civil enforcement. It'll be interesting to see if Texas drops this law now that they can actually outright ban it. Because they only came up with this as a way of getting around Roe. So now they don't have that impediment anymore, do they? Other potential ramifications and questions that have arisen, as we all know, women in marginalized demographics are the most severely impacted by this decision. Despite Justice Kavanaugh's assurances, in my opinion, all SCOTUS-approved rights flowing from the 14th Amendment are now in danger of being eliminated. One state, I'm trying to remember where, I think it was Louisiana, said they're all ready to take on Obergefell, challenging same-sex marriage. Laws in most states are all over the place, leading to increased litigation and uncertainty for patients and medical professions alike. As I said, that there's a whole article in the resources that discuss all of the different perceived litigation coming up. Here, this is a biggie: women's medical information on the internet, ranging from everything from mail order abortion medication, period tracking apps, email and text exchanges that are meant to be private with one's loved ones, mother, sister, best friend. All of that is going to be subject to subpoena in these anti-abortion states. Some good news: I recently read an article in the LA Times that Apple is already geared up to delete data that they have gathered on the period tracking app. And another one said that Google is prepared to purge the searches, client searches for abortion services. So that's a good news. Let's hope that they continue in that trend. Of course, those are going to be challenged on a variety of bases, and all of that's going to be subject to ongoing litigation. Here's one that a lot of people don't think about. So let's say that a husband and wife, or a woman and her partner, are residents of Texas, and they sit down and decide that she's pregnant, and they together decide that she should have an abortion, and they decide that she should go to New Mexico. Let's say they're in Texas and New Mexico is right next door, and they decide she should go to New Mexico to get her abortion. And New Mexico has laws like California that I'm going to go over in just a second that say no harm can come to her while she's in their state. But because they conspired, because they reached the agreement in Texas, that's part of a conspiracy, and the conspiracy originated in Texas, so the husband can be prosecuted for conspiracy to commit a crime in the state of Texas. It's just awful stuff. All right, questions on just 3 and 4, and then I'm going to wrap up with what we can do about all this.
Okay, Kathy, I'm going to go through a few questions from this section.
Okay.
So from Jenny Redfern, would a pro-choice amendment to the California Constitution be bulletproof?
Can you say that again?
Would a pro-choice amendment to the California Constitution be bulletproof?
Okay, I'm going to address that in the next section, because I'm going to talk about the amendment that is pending, and I'm going to talk about its ramifications at that point. If you can just hold on to that one.
Okay. So I think the one from Linda Geyer would be something similar. Do you see a boilerplate state sample law that we can support in each state?
I think the discussion on the amendment is going to answer that question as well. Yeah.
Okay. Christina Ruckert asks, can we stretch wrongful life cases past children born with severe disabilities and apply it to women who are forced to bear children they do not want?
Can we, one more time?
Can we stretch wrongful life cases past children born with severe disabilities and apply it to women who are forced to bear children they did not want?
This case, ladies, Dobbs says that any state can enact any law that can force a woman to have an abortion for any reason.
Okay.
And it's up to the states completely. There's no holding in the decision that says states must carve out an exception for deformities. There's no exceptions that states, there's no statements that states have to carve out an exception for any purpose. So it's completely up to the states to decide what they think is best for the citizens of their state.
Okay, I think we have some other questions, but most of them might be answered by by the next section. So
Okay.
We'll come back to them if I don't see one. Go ahead, Rand.
Perfect. Yeah. If I don't get to them, then we'll come back at the end. Okay. Then we're going to wrap this up with what can and can't be done. So I'm going to break this down into different parts. We'll look at what can be done at the federal level, and that has two subparts. One is the executive branch and the other is the legislative branch. Then we'll look at the state level, and then we'll look at the local level, you and me, what can we do? So first, with regard to the executive branch at the federal level, that basically means the president and his or her cabinet. We'll just say his cabinet. We have a male president. And their respective offices. So what about executive orders? Can't the president just issue executive orders to overcome this? The truth is, basically no, is the easy answer. The president's ability to issue executive orders is very limited, first of all, as to the subject matter that he can use them for. The second problem with executive orders is that they can be reversed. They're not ironclad law. They can be reversed by the next president. So there's lots of limitations. The main obstacle is what's called the Hyde Amendment. And this comes from a case that was enacted by Congress that says that federal funds cannot be used in any manner whatsoever to support abortion services. So that limits how much the president can do, because mostly what he can do involves the expenditure of certain federal funds. Even that's very limited, but it almost always involves the expenditure of federal funds. And since the Hyde Amendment says none of those can be used on abortion services, that's really limits what he can and can't do. Some things that can be done and have already been done. In December, the Federal Drug Administration approved the abortion pill via mail. Prior to that, a woman had to go to a clinic or to a private doctor and have an examination and have the pill prescribed to her. But now she can just do it through telemedicine and get it through the mail. So then that raises its other questions. Well, can women who are in an anti-abortion state still receive the pill in the mail? Again, maybe not. It's good news is the U.S. Postal Service has declared that it will not assist states in enforcing its laws, which means it's not going to have its carriers sit there or the sorters sit there and go through every package to try to determine whether or not it has illegal abortion pills in it. But that will not stop many states from devising ways to find out if women are receiving these packages. So that's something that remains to be seen. And then again, somebody raised the question, can't the president agree to have clinics set up on federal lands? Two things President Biden has already addressed this and said he won't do it. I'm not quite sure why, but it may be because of Hyde. This does raise a Hyde issue. If the clinics lease the property from the feds, then they have to make payments, and those payments involve funds that are going to abortion services. So it wouldn't be possible anyway. even if he were willing to do it. What about Congress? So let's look at the legislative branch at the federal level. One thing they can do is pass the Women's Health Protection Act, the WHPA. This was devised to codify Roe's protections. And this came up last year. This is not a post-Dobbs thing that they just came up with, but they did it in anticipation of Roe being overturned. So they sought to codify Roe's protections. It did pass the House last year. It went to the Senate and it was heard. Well, it wasn't even heard. It got to the Senate in May and McConnell squashed it from even being debated. So it's just sitting on the Senate floor at this point in time. Doesn't mean it can't be revived if we were to get a Democratic majority in November. The likelihood of it being revived is pretty good. However, the bad news is, in my opinion, I think it would be likely to be found unconstitutional. For all those reasons that I went through, why Congress can't enact the law outlawing abortion in all states, for the same reason I don't think they have the authority to enact the law protecting abortion in all states. So there's a really good article that I included in the resources written by a prominent constitutional attorney, and he agrees with that assessment. So take a look at that if you want to get a little more in-depth view that I don't have time to go through at this point. They could also, via the Commerce Clause, pass a law prohibiting states from preventing mail-order contraceptives and abortion pills. The Commerce Clause, as I said before, if you remember that Congress does have authority to make laws that involve interactions and activities between states or among several different states. That's all because of the Commerce Clause that gives them that authority. So they could do that. Somebody asked, do you think it would have made a difference if the ERA had been passed and was intact at the time of Dobbs? Do you think it would have had a different outcome? I've put here probably not, for two reasons. Here's what it says: equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. So what that would do clearly would be, for instance, this is far-fetched, but just to show you how it works, if there were a law that said men could have abortions, but women can't have abortions, obviously the equal protection section of the 14th Amendment has been violated because they're not being treated equally. But there'd be a real question. That would have to be a very different kind of analysis to determine whether or not equality under the law encompassed a woman's right to enjoy equal privileges and opportunities that men have if they're forced to carry children. That would be the analysis. I'm not so confident about the outcome. And I can tell you outright, if that came before this Supreme Court, it would not change the outcome. They had, as I've said, they had predetermined the outcome, and they would find a way to get around the ERA even if it was there. Okay, what about the state level? What is California doing? I have nothing but good news finally. Sorry, I've been such a Debbie Downer all the way through this, but actually here in California, we're doing great things. We're proud and happy to be living in this state at this time. Let's start with this development that came about in September of last year. Senate Pro Tem Tony Atkins put together a coalition of 40 reproductive health organizations, and this was in direct response to that Texas SB 8 civil enforcement law, and in anticipation of the demise of Roe. And they proclaimed California to be a reproductive freedom state, which basically said our doors are open to any and all women from anti-abortion states who need to find a safe haven for an abortion. And they developed 40 recommendations to protect, strengthen, and expand abortion services in California. This led to the introduction of 8 bills. I don't have time. They're all here, and you can look at them, and they're also on our bill tracker that you can find on our website. I'm just going to address a couple of them. I want to talk for a second about AB 1666. I'm very proud of this law. This was a law that our public policy team chose to be a co-sponsor on this bill, and our advocate, Kathy Von Austin, spent a lot of time shepherding this through the legislature to get it passed. And it was passed by the legislature, and it has been signed into law, and get this, on June 24th. how's that for irony? This basically says that anyone who comes from a state that has one of these civil enforcement laws on the books, if someone has a civil judgment or a civil case filed against them, and they come to California, that civil judgment cannot be enforced and will not be enforced in a California court. So basically, providers are safe, patients are safe, as long as they're in California. A couple of these others deal with liability coverage, providers, and insurance coverage for patients, helping them with coverage. And SB 1375, and a couple, 1375 and another one, a couple of these deal with kind of beefing up our providers because, getting ready for this onslaught of out-of-state women coming into our state. We need to make sure we have the infrastructure we need to support them. And so SB 1375 authorizes nurse practitioners to perform certain types of abortions. This was a high priority bill for our public policy team. It has passed the Senate. It's sitting in the Assembly right now, and it will be heard next month. And then I want to talk about SB 1142. This is a budget measure, and it has 3 provisions. And basically, what it's about is providing funding to beef up the infrastructure for those abortion fund organizations. That means 501(c)(3)s who exist solely for the point of raising funds to assist out-of-state women in getting abortions. It develops an information center for these out-of-state patients. And as I said, provides infrastructure support systems. And finally, what you were asking about before, we now have the introduction of a constitutional amendment to our state constitution. It's called SCA 10. And this has passed the legislature. And again, AAUW California was a strong supporter of this amendment, and Kathy did a lot of work on helping getting this through. And this is basically, so now it will appear on the November ballot as a proposition. And here's what it says. The state shall not deny or interfere with an individual's reproductive freedom in their most intimate decisions, which includes their fundamental right to choose to have an abortion and their fundamental right to choose or refuse contraceptives. This section is intended to further the constitutional right to privacy guaranteed by Section 1, that's Section 1 of our state constitution, and the constitutional right to not be denied equal protection guaranteed by Section 7, that's also of our state constitution. Nothing here narrows or limits the right to privacy or equal protection. A couple of really important things about this that I hope will answer your previous questions. This language was very intentional and deliberate, saying that this right depends on the provisions of the California Constitution. And that, coupled with California Constitution Section 24, which is already part of our Constitution, says that rights guaranteed by this Constitution are not dependent on those guaranteed by the United States Constitution. So if our constitutional right per this amendment were linked directly to the 14th Amendment, in other words, if this amendment says these rights come from directly from the 14th Amendment to the United States Constitution, and the Supreme Court has just found that the 14th Amendment does not protect these rights, then we would be a step further in having this constitutional right in jeopardy. But because we have linked it only to our state constitution, which says that all these rights are not dependent on the U.S. Constitution, I think that if this constitutional amendment passes, our law and our amendment are both going to be safe. So what that means is, you'll see in a minute, you got to get out there and help us get this amendment passed. All right, finally, local level, what's being done? What more can we do? So what's AAUW doing? AAUW National is working in coalition with the Center for Reproductive Freedom and other coalitions to get the WHPA passed in the Senate. They will continue to do that. AAUW California, as you saw, we're supporting 4 abortion-related bills in the legislature, and we're co-sponsor of one of those. and also a supporter of the state constitutional amendment. That's your public policy team at work. There have been some other suggestions for AAUW California that came out of the registration questions, and I'll address a couple of those. Somebody asked, what can we do to work to overturn the Dobbs decision? Just to re-emphasize, this is not possible. I'm so sorry to tell you. SCOTUS is the final say. There is no other body to appeal to. This is it. This question came up at least 4 times, if not more, as I recall. How do we go about getting involved in, or can we, as an organization, organize a list of homes where out-of-state women can stay? And I think that's wonderful that our members, so many of our members, are thinking about this and wanting to do this. I have a couple of comments on that, though. As you saw, there's an actual bill coming out of the legislature where they're providing money to help fund organizations who are already doing this. So I'm not sure it's really necessary for us to do it. And in fact, I'm going to read you just a short thing I found in another article in the Times where this was being discussed. And an abortion rights activist actually chastised those who were offering these services, quote, because abortion rights groups are already developing procedures for this, and the amateurs were likely to make a mess of it. That's kind of their assessment, and they're basically saying, hey, back off, we've got it. But what we will do is I will take it to our public policy committee when we meet at the end of this month. We'll discuss whether or not that's a project that we would like to take on, if we have the resources and skill sets to do something like that. And then even if the committee agrees, then it has to go to the board for approval. So stay tuned on that one. And then at the branch level, there was a question, does our 501c3 status prevent us or prohibit us from engaging in pro-choice political activities? Absolutely not. We can support causes, and that's what we do. That's what advocacy means. We advocate on behalf of causes that are supported by our public policy priorities, and the right to choose is one of those priorities. So we definitely can engage in those activities. We just can't support politicians or one party over another generally. Branches may organize their own local networks to host out-of-state patients, but keep in mind what I just read you. I suggest you contact your local Planned Parenthood agency. Find out what they're doing around this. This is their specialty. This is only one of many, many, many of our public policy priorities. This is what Planned Parenthood does. They are the experts. What are they doing? How can your members help them? How can you help them as a branch, as an organization? Invite a representative from your local Planned Parenthood to come and be your program speaker and talk about these issues. And the one I didn't put in here is donate. Donate to Planned Parenthood, donate to NARAL, any other pro-choice organizations are the ones on the ground doing all this work, and they need all the help they can get. And then finally, participate in our Get Out the Vote. It's really going to be a voter education campaign this fall. Prepare a comparison of pro and anti-choice candidates. You're certainly welcome to do that as long as you don't advocate on behalf of either one of them. But you can educate the public as to what their stances are. And then finally, there's some things you can do as individual members. Get engaged and participate in the process. As I said, educate yourself about your own representative stance on abortion rights. Participate in your branches, Get Out the Voter education campaigns, and support this amendment. Support AAUW California efforts to spread the word about it and get others to vote for it. Our public policy team is going to have a subcommittee led by Sue Miller on our voter education efforts for this year, and this amendment is going to be the focus of our voter education. So stay tuned. We'll be letting you know a lot more about what you can do and how you can help, and please pay attention to that and pitch in. You can offer to be a speaker to other organizations that you belong to on these issues. And finally, you can volunteer for voter education efforts in abortion restrictive states. to help them change the makeup of their legislature, but this comes with a big caveat. I can't emphasize this enough. This is something you can do in your individual capacity. If you're involved in a letter writing campaign or a call and texting campaign on behalf of a pro-choice candidate, you can do that as an individual, but you cannot do it as an AUW member. You can't use your AUW affiliation in those efforts in any way. It's only as an individual. Phew, I think that's everything. I did it in an hour and a half. That's the best I've done in all my practices. I want to thank you all for listening. And if you want to stick around for a few more questions, I'm happy to take those. If there's anything I could possibly have left out, I'm happy to address it at this time. And I also want to make sure you're aware, as I said, I've got 2 slides here that have a whole bunch of different resources if you want to do more reading on any of these issues. And with that, Linda or Rhonda, you have any, Brenda, you have any?
I would like to remind people that you will be seeing all 21 of these questions, and if there's needed to be an answer, you'll be answering them when the information comes out. But I think that a really wonderful way to end tonight would be to read Sue Sutton's question. How does this decision affect vasectomies? Will they be allowed?
I have no answer to that question. The easy answer is this decision will have no effect on vasectomies. Although it's an intriguing question. It's an intriguing thought that somebody may actually raise an equal protection clause, as if, especially, I mentioned before that if one of these states come up with a law that says that conception, that life begins at conception, and abortion pills are precluded or are outlawed, or wait, so let me rethink that. Birth control, let's focus on that. If birth control pills are outlawed and can't be saved by Griswold because its holding no longer exists, then we would have a really valid equal protection clause about vasectomies, I think. I think it could come up in that context, but on its face, Dobbs doesn't really address it. And that's all I have to say about that.
Thank you very much,
Kathy.
Kathy. This has been so enjoyable and interesting and enlightening. I certainly appreciate it. And so on behalf of all the people that were listening tonight and joined us, thank you so much.
Great, my pleasure. Thank you all so much.
Thank you. Kathy and Linda and Rhonda, please stay while everybody else exits.
Will do.
And Rhonda, I think, can you help me with the exiting of our attendees?